Today I'll be focusing on the Coronavirus Act and what changes this has made to existing legislation and the practice directions. I will first be giving an overview of the most important temporary amendments that have been made and how this has expanded the use of live links in criminal proceedings and hearings. I will also briefly touch on relevant sentencing considerations that may be taken into account during this time. Much of the content I will speak about regarding the Coronavirus Act is contained in a handout that will be made available afterwards. Turning first to the effect of Schedule 23 from the Coronavirus Act and the amendments it has made to Section 51 of the Criminal Justice Act and Part 18 of the Practice Directions. Normally under Section 51, a witness other than the defendant may be able to give evidence through a live link in certain criminal proceedings. Live link was defined in Section 56 as a live television link or other arrangement by which a witness is able to see and hear a person. The 2020 Act has extended the definition of live link to include live visual link and a live audio link. It is worth noting at this point that the use of a live audio link is the exception rather than the norm during these times. When live audio links can and cannot be used will be dealt with a little later on. Section 51 has been extended to enable any person to take part in eligible criminal proceedings. This now enables a witness, defendant, and judge to take part of a live link. However, the amendment does not apply to any jury member. Before the Coronavirus Act, live links could only be used to give evidence. Now, people can take part, meaning a person is able to give evidence, but are also able to attend the proceedings when not giving evidence. Prior to the 2020 Act, there were a list of 7 types of criminal proceedings that live links may be used in. Not only has the 7 already named widened in scope, but additional proceedings have been included in this list. It now covers any proceedings that are preliminary or incidental to a criminal appeal, to the Crown Court or Court of Appeal, instead of just the appeal itself, and any trial in the Crown Court instead of just a trial on indictment. I don't intend to read this new list out, but you will be able to see this in the handout of what amendments have been made. As previously mentioned, audio proceedings are the exception. The Coronavirus Act has introduced Schedule 3A to the Criminal Justice Act. It sets out what proceedings may be conducted wholly as audio proceedings and/or wholly as video proceedings. However, all of the named proceedings that can take place over audio live link are subject to a number of exceptions. Namely, the defendant may not give evidence via audio link during any of the named proceedings, and any other person may not give evidence by audio link unless there are no suitable arrangements for the person to give evidence by video link and the parties agree. Before all this, and before a live link direction can be made, the court must be satisfied that it is in the interests of justice, and parties to the proceedings have to be able to give the opportunity to make representations. If the defendant is under the age of 18, then the relevant youth offending team has to be given that chance to make such representations. There are a few other important points to note. The amendments now mean that a person who takes part in proceedings over live link are treated as being present in court and complying with any requirement to attend court or surrender to the custody of the court. The court still has a little flexibility under the amendments. Live link directions may be applied to some or all participants. They may apply to only some aspects of a person's participation in proceedings, like the giving of evidence, and they may apply to persons outside of England and Wales. In the Magistrates' Court, a single justice is able to give live link directions. Schedule 24 expands the use of live links to live video and audio links and to all participants during certain preliminary, sentence and enforcement hearings. Much of what has already been said applies to these type of hearings. I will now focus on how the amendments apply to specific circumstances. As previously mentioned, defendants are not able to give evidence by live audio link. In certain proceedings, the defendant is unable to take part at all by live audio link, including contested bail applications, when the court is minded to deal with someone for contempt of court, and sentencing. In each of the above, a person other than the defendant may not take part by live audio link unless they do so only to give evidence. There are no suitable arrangements for that person to give evidence by live video link, and the parties agree. The court is unable to do certain things if a person takes part by live audio link unless they do so for the purpose of giving evidence. This includes refusing or revoking the defendant's bail if the defendant objects, taking a guilty plea, or dealing with someone for contempt of court. Under Schedule 25 of the Coronavirus Act, the court has the ability, when proceedings are to be conducted wholly over live link, to direct that the proceedings are to be broadcast so members of the public can see and hear, and they may also direct a recording of the proceedings to be made so the court can keep an audio-visual record. The court can only do this when all persons taking part in the proceedings do so through a live video link or through a live audio link. There is no provision where it is a mix and match scenario. A common theme that can be seen throughout these amendments is the focus and emphasis placed on using a live video link as much as possible. It perhaps recognises the importance of being able to see someone's face rather than just hear their voice. Live audio links are very much the exception throughout all of this. It is an option, considering the restrictions on movement in the UK at the moment and the fact a person may be unable to access a live video link. However, as far as possible, people are encouraged to use a live video link. Turning now to sentencing at this time. The Lord Chief Justice, in a judgment yet to be made available, outlines some important and relevant considerations to be taken into account when sentencing. In accordance with established sentencing principles, the court will take into account the likely impact of a custodial sentence upon an offender as well as others. Therefore, it is relevant that the impact of a custodial sentence is likely to be heavier during the current state of emergency. Those in custody are confined to their cells for much longer periods and are unable to receive visits. It is perhaps also of relevance the anxiety both the offender and their families might have about the risk of coronavirus in custody. Applying ordinary principles, where a court is satisfied that a custodial sentence must be imposed, the likely impact of the sentence continues to be relevant to the necessary length of the sentence and whether it can be suspended. The considerations I have spoken about and the impact of coronavirus on custodial sentences may be a factor in reducing the overall sentence to be imposed or suspending it. The question is now, when will these amendments and changes to criminal procedure no longer be used? The Coronavirus Act is time limited for 2 years, unless there is a formal parliamentary approval for it to continue beyond that point. Therefore, for the time being, it seems most criminal proceedings and hearings will be conducted as far as they can be via live link. What this means for jury trials is yet to be seen. Thank you.